Hey guys, welcome to Academy and welcome to this very special class on the Unacademy Legal World where we are going to talk about the personal data protection law. Is your personal data really safe in India? Is the question that we are going to examine in today's class. How are you guys doing? कैसे हो आप सब लोग? Welcome to the class. जल्दी से बता दो कि क्या आप लोग मुझे देख पा रहे हो, सुन पा रहे हो, नहीं कर पा रहे हो क्योंकि पिछले कुछ दिनों से we were facing yes. So here we are. Let's start today's session. आज के सेशन में हम बात करेंगे कि क्या आपका पर्सनल डेटा वाकई में सेफ है और हमें पता कैसे चलेगा पर्सनल डेटा सेफ है कि नहीं। अगर वाकई में इंडिया में कोई कानून होगा विच विल टॉक अबाउट द सेफ्टी ऑफ द पर्सनल डेटा। Recently, you must have heard about a news that came in the month of August that the government has decided to withdraw a bill from the parliament. What did that bill talk about? It talked about the personal data protection bill. Now, as unfortunate as it was, the withdrawal of the bill created a lot of conflict, not just among the bench and the government and the opposition, but as well among the people in this country in general. So today we are going to cross through that controversy and understand why has the personal data protection bill really been withdrawn. All right. चलिए तो सबसे पहले तो मैं अपना आपको इंट्रोडक्शन दे दूं। मेरा नाम दिव्य है, मैं आपका अनअकैडमी क्लैट एजुकेटर हूं। I've been a CLAT aspirant like all of you are. I got an All India rank of 16 in CLAT, All India rank of 17 in IELTS. I've been mentoring CLAT aspirants for the last few years, and here at Unacademy, it is my mission to make your CLAT preparation simple and sensible. So, in today's lecture, I have structured this session in this way. I'll talk about first how what was the PDP bill actually was. Then we will understand the need for a privacy protection law. Then what was the problem with the bill, the journey with the JPC, why did the government really withdraw it, and how will the new bill look like, and when is the new bill really coming? These are the few things that we are going to talk about in today's class. So what was the PDP bill really? In order to understand what it was really, I have taken the context from the preamble of the act. Every time an act, legislation or bill is presented in the parliament, we know that a general statement of intent and purpose, a statement of purpose is always annexed to it. What did the statement of purpose of the PDP bill talk about? It said that the bill is being enacted to provide for the protection of privacy of individuals relating to their personal data, specify the flow and uses of personal data, create a relationship of trust between persons and entities processing the personal data, protect the fundamental rights of the individuals whose personal data are processed, to create a framework for organizational and technical measures and processing of data, laying down norms for social media, intermediary cross-border transfer, accountability of entities processing personal data, remedy for unauthorized and harmful processing, and to establish a data protection authority of India for the said purposes and the matters connected therewith or incidental thereto. So many things that the PDP bill was trying to do. Basically, to cut the long story short, you should understand that India lacked a privacy law. All of us, while we are accessing internet, are creating a lot of personal data. Right now, as you are watching this lecture, as you are watching this video, you are creating some amount of personal data. Now, this personal data are in the hands of several people known as intermediary. Who are those people known as? Those people are known as intermediary. Now, how well those people are going to use it? Are they going to use it for some nefarious purpose? Are they going to use it to cause harm to you? Are they going to use it to get some amount of money or to surveil on you? Are some of the things that we are already always concerned with. Now, to give a legal framework, to tell us, to specify what are the different uses that people can use this data for is something that the PDP will tell us about. It would have created a framework on how to use the personal data of the client. It would have created a framework to protect our fundamental rights. What fundamental right exactly? The Article 21 right as enunciated by the Supreme Court in the privacy law judgment. What was the privacy law judgment? The Puttaswamy case. Right? Obviously, all of us know that there was a Justice J.S. Puttaswamy case in which it was said that we all of us have a right to privacy. ना जब सुप्रीम कोर्ट ने हमें ये बता दिया कि हमारा राइट टू प्राइवेसी है, गवर्नमेंट के अंदर एक होड़ मच गई, एक इच्छा हो गई कि अब हम प्राइवेसी के ऊपर एक कानून लेकर के आएंगे। और प्राइवेसी के ऊपर जो कानून लेकर के आया गया वो था हमारा पीडीपी बिल। वो क्या बन गया? वो पीडीपी बिल आकर के बन गया। अब पीडीपी बिल में ये बताया गया कि किस तरह से प्रोटेक्शन होगा प्राइवेसी ऑफ इंडिविजुअल का। जो कि उनके पर्सनल डेटा से रिलेट करेगी, स्पेसिफाई और फ्लो होगा, सब कुछ यहाँ पर होने वाला था। भारत का प्रिवेसी कानून, ये पीडीपी लॉ होने वाला था। अब इस कानून की नीड क्या पड़ी, आखिर ये कानून हमारे लिए जरूरी क्यों था? देखिए, आज से 10 साल पहले लगभग जस्टिस एपी शाह कमेटी रिपोर्ट आई थी, जो कि प्रिवेसी की बात कर रही थी। आज से 5 साल पहले 2017 में पुत्तौस्वामी जजमेंट आया था, राइट टू प्रिवेसी वाला जजमेंट। और 4 साल हो गए जस्टिस बी एन श्री कृष्णा कमेटी रिपोर्ट को। इस बीच हमने देखा कि पूरी दुनिया अलग अलग तरह से अपने आप प्रिवेसी का कानून बना चुकी थी। यूरोप में जीडीपीआर आ गया था, जनरल डेटा प्रोटेक्शन रजीम। उसके अलावा भी अलग अलग कंट्रीज में अलग अलग तरह का लॉ आ गया था विच टॉक्ड अबाउट प्रिवेसी। बट इंडिया में अनफॉर्चुनेटली ऐसा कोई लॉ मौजूद नहीं था। इसलिए भारत में हमारे पर्सनल डेटा को प्रोटेक्ट करने के लिए एक नीड, कई सारे लोग जैसे जिनका ये स्टेटमेंट है, this statement is from an endless alum, Apar Gupta, who runs a very good organization. He talks about Center for Internet and Society, I believe, if I'm not wrong, CIS, where he says that each day that is lost causes more injury in the. लगभग 10 साल पहले नीड लगी थी सबसे पहली बार इस लॉ को, और 10 साल से हमने अभी तक इस लॉ को नहीं बनाया। तो जितना समय हम गवा रहे हैं वो हमको सिर्फ इंजरी और हार्म कॉज कर रहा है, right? It is causing us a lot of injury and it is causing us a lot of harm. All right. So what was the problem with this law? So you all know that the government has presented this law. गवर्नमेंट ने ये लॉ को प्रेजेंट करा, और लॉ को प्रेजेंट करने के बाद अब उन्होंने इस लॉ को विड्रॉ कर लिया है। अब इस गवर्नमेंट ने इस लॉ को विड्रॉ क्यों किया है? व्हाट इज द रीजन, व्हाट आर द प्रॉब्लम दैट द गवर्नमेंट थॉट दैट इट हैड, है ना? सो फर्स्ट, there were multiple problems with from multiple people such as startups, big tech, civil society. अलग अलग लोगों ने अलग अलग तरह की प्रॉब्लम फेस करी। स्टार्टअप्स को क्या प्रॉब्लम थी? स्टार्टअप्स को लगता था कि इसने इतने सारे कंप्लायंसेस बढ़ा दिए कि एक स्टार्टअप के लिए अब व्यापार करना या शुरुआत करना खुद की पॉसिबल नहीं था। बिग टेक में मैं किसको रखूंगा? फेसबुक को रखूंगा, गूगल को रखूंगा, ये सारी कंपनीज होती है। तो बिग टेक का ये कहना था कि वो इस बिल में देखती थी कि देयर वर ऑनरस डेटा लोकलाइजेशन रिक्वायरमेंट्स, देयर वर सेवरल अदर रिक्वायरमेंट विच वर नॉट सो ग्रेट। और फिर लास्ट में सिविल सोसाइटी थी। सिविल सोसाइटी भी इससे नाखुश थी क्योंकि ये गवर्नमेंट को काफ़ी ज़्यादा बड़ी पॉसिबिलिटीज दे रहा था, और गवर्नमेंट क्या कर सकती थी इससे? गवर्नमेंट कैन बेसिकली इन्वेड योर राइट टू प्रिवेसी। तो गवर्नमेंट कहीं ना कहीं आपकी राइट टू प्रिवेसी को इन्वेड कर सकती थी, और ये यहाँ पर एक प्रॉब्लम थी। अब डज एनीवन हैव एनी डाउट? यहाँ तक किसी को कोई भी डाउट है क्या? इफ यू हैव एनी डाउट प्लीज फील फ्री टू आस्क मी। Now let's understand how the journey of the bill moved. Now admittedly the first report, Justice AP Shah committee report on privacy, did not have anything. Okay, it neither created any incentive for the current government to take any action, nor did the government take any action. The first incentive to the government came when the Supreme Court in 2017 gave us a privacy law judgment. This privacy law judgment, which was known as the Justice Swami versus Union of India, in this particular case, the Supreme Court declared right to privacy to be a part of fundamental right. Now, if you may wonder, where did they read this fundamental right from? Because as we have read our constitution, we have never found right to privacy. What constitution was Supreme Court really reading it from? Supreme Court was reading it from our own constitution, but was interpreting an article that already existed in a way so that it includes right to privacy within its ambit. It was rereading Article 21, expanding its scope to include the Article 21 within it. Therefore, when the status of the right to privacy was increased to it being a fundamental right, it was imminent that the government should create a framework that should protect it, because there should not be any right without any remedy. And if right to privacy was going to be a law which was going to be without remedy, then it would have caused irreparable damage to the framework of protection under our country. So, for that purpose, the government in 2017 decided that we are going to create a law. Okay. Now, when the government decided that it is going to create a law, it appointed a committee. This committee was the Justice Shri Krishna Committee. Now, Justice Shri Krishna Committee started with drafting a white paper on in the same year. What is a white paper? White paper basically reflects your ideas, intent, and how you're going to do about a task. So it's more like a proposal, but a detailed proposal at that, which you float for the general member of the public to understand, and then probably give you certain feedback so that you can improve and undertake your task in a better and more effective way. What happened after Justice B. N. Shri Krishna released the white paper? Came 2018. The committee submitted a draft data protection bill. So Justice B. N. Shri Krishna, है ना, दिव्य आईलेट वन लाइनर क्लास प्लस में होता है क्या? वन लाइनर की क्लास नहीं होती यार प्लस में आईलेट के लिए, है ना, नन दैट आई एम अवेयर ऑफ. बाकी आईलेट के लिए अलग कई और इम्पोर्टेंट क्लासेस होती है प्लस में. अब जुलाई 2018 में व्हेन द जस्टिस बी एन श्री कृष्णा कमिटी completed its report, it also created a draft data protection bill. This draft data protection bill was the bill that it could have given to the government and said, okay, government, take this bill and do the necessary task. So this was submitted to the Ministry of Electronics and IT, which also said that it would draft a fresh bill borrowing from the ideas presented in the Shri Krishna committee bill. Okay, so this was what the Ministry of Electronics and Information Technology said. Okay, एक जो बैकलॉग कोर्स है ना नंदिनी हमारा जो प्लस पे होता है उसको आप ज्वाइन कर सकते हो. Now after this happened in July 2018, in 2019 the bill was referred to the Joint Parliamentary Committee. Now every time a bill comes to the parliament can discuss it. But if there seems that there are going to be multiple objections to the bill, the better thing to do is instead of wasting precious parliamentary time debating upon it, we just send it to a JCP or a JPC. What is the Joint Parliamentary Committee? A Joint Parliamentary Committee is a committee of experts which may include several MPs who have certain distinction in those areas, who will then debate upon the bill, the implications of the bill, and they may also invite people from different strata of the society. They will have to appear before the Joint Parliamentary Committee, tell them what's wrong with the bill, what's not wrong with the bill, give them their perspective, and then they can give Parliament a report. They can submit to Parliament the report as to why they think there should be certain recommendations and amendments to the bill. Now, it was headed initially by BJP's Minister of External Affairs for State right now, Meenakshi Lekhi. And then they started doing a clause-by-clause analysis of the bill. It also sought and received extension for presenting its report in September 2020 and March 2021. So firstly, they had a limit of 6 months. They had to submit in September 2020. They could not submit it. There were multiple reasons, COVID included. So they sought another response. They could not submit it. They said, okay, we will submit it in March 2021. Now, even in March 2021, the job of the committee was not finished, obviously. So in July 2021, another person took over the committee, BJP MP PP Chaudhary, and he was appointed the chairperson of the JCP. Once Lekhi was promoted to another task. Now the JCP was received yet another extension because committee wanted to do work but it was unable to do so. So they received another extension. And once they received another extension in December 2021, the JCP tabled its report in the parliament, which Justice Shri Krishna said was heavily in favor of the government. In a media interview, he said that the bill could turn into an Orwellian state. Again, you go back to the concern that the civil society raised. Civil society ने भी यही concern raise करे थे कि Orwellian state बन जाएगा. Now that's what it is becoming, right? So this was bad about the bill. Then what was the reason of withdrawal really? So after considerable deliberation and examination of the JCP report, it was found that there is a need for comprehensive rewriting of laws and rules, taking into account some of the JCP's comment and the emerging challenges and opportunities that arise from there. A comprehensive approach to the laws will be undertaken by the government and we will come back to the parliament very quickly after following the process of consultation. Now this is obviously a statement given by the Ministry of Information Technology. What did they say? That once they read the JCP report, they realized that they have recommended so many different amendments that it's almost like a redrawing of the bill. Now, if it's redrawing of the bill, it is better that we draft a new bill. And there is another rumor that is going around, courtesy several newspapers, that says that the government is also trying to draft a new IT law, an Information Technology Act. Now, if they are trying to draft a new IT Act, it also becomes clear that once you have a new IT Act in picture, you may end up you may end up making a comprehensive legislation, है ना, आप एक comprehensive legislation बना दोगे. और उसके अलावा they are also saying that they will have a comprehensive approach to the law which will be undertaken by the government, and they will come back to the parliament very quickly. So what will the new bill look like? So we do not know the specific provision, but a senior official said that on the question of data localization, the government is considering whether to add it to the planned new version of the Information Technology Act, and whether to allow cross-border data flows only to trusted geographies. The thinking is that the data should never be stored in a region that is trusted by the Indian government, and that data should be accessible in the event of a crime. So that is the reasoning that they are giving. And when will the new bill be ready? People are saying that it is going to be ready in the winter session of the parliament. So let's see if it really gets ready by then, or if not. So we will know when the time comes to it. Alright, guys. So this was all about the data protection regime and this new law. So with this, we come to the end of the class. Let's crack it. Unacademy, let's crack it. Have a great day, and we'll meet again. We'll keep meeting on this channel. Okay. Yes, the 4 p.m. wali class is sufficient. Okay, guys. Are there any doubts? So this was about the personal data protection bill. अब देखते हैं आगे क्या होता है. Yeah. Have a great day, guys. Thanks a lot.